Welcome, and thank you for joining us today for a Land Services SA webinar on electronic lodgement policies and procedures. This is a pre-recorded session with a live Q&A session at the end of this presentation. We ask you to kindly hold all your questions until the allocated time, where one of our subject matter experts will be able to assist. Land Services SA is committed to providing an excellent customer experience. One way we continue to deliver value to the industry is through our industry education program, where we produce a range of helpful educational materials, hold regular webinars, and host industry events. Our industry education program addresses key topics or frequently asked questions to ensure you remain up to date with contemporary practices. We want to help set you up for success and believe helping with industry education will assist in reducing the volume of requisitions, meaning a quicker and more seamless experience for you and your clients. Land Services SA's subject matter experts assist in delivering our industry education program, utilising their years of experience and respected place in the industry. This webinar has been prepared by Natasha Stupel. Natasha is our Registration, Training, Audit and Workflow Officer. Natasha has over 35 years experience in land titling and has worked on a number of flagship projects such as SALIS, e-conveyancing, residual dealings, and most recently the alignment of paper and electronic panel forms. This webinar will cover the top requisition types relating to electronic lodgements and aims to address areas of concern or confusion. We hope this information will assist you in the future when preparing documents for lodgement with your electronic lodgement network operator. Requisitions are still frequently raised in relation to attachments. As regards mortgages, encumbrances and leases, the attachment containing the covenants or terms and conditions should be uploaded without panel form pages and certification pages. When the dealing is registered and completed, the uploaded attachments merge with the rendered form to create an image of the complete dealing. When non-required pages are included in the attachment, a requisition will be raised requesting that you print only the required attachment pages, double-sided, and attached to the requisition dealing. Standard terms and conditions for mortgages and leases, which are already deposited with Land Services SA, are not required to be uploaded as an attachment. The standard terms and conditions deposited number should be referenced in the space provided in the ELNO workspace. Mortgagee and encumbrancy consents must be attached as a consent and not as part of the covenants, as this impacts how the consent panel appears on the rendered form. If not attached as a consent, the consent panel will state not applicable. For transmission applications, a full copy of the probate with the will annexed is required. Please ensure that the probate date is legible and not scrambled. Please ensure that a registrar certificate for each certificate of title referenced in the dealing has been attached. This is an example of a rendered form of a transfer lodged electronically. This is what we see when examining the dealing from the data you have entered in the electronic workspace. We will be focusing on the transferor, consideration, and transferee panels, detailing the common errors and their solutions, and explaining data requirements. The transferor details are populated from the title. However, if one of the parties' names have changed, a name tie-up and justification must be included. For an individual as transferor, the new or correct name, how they are registered, and the reason for the change must be referenced, for example, as a consequence of marriage or resumption of maiden name. Where applicable, evidence of this change must be retained in your file for the prescribed period. Likewise, a mortgagee coming off the title through discharge or transfer, and whose name has changed from how it was registered, a tie-up and the appropriate justification must be selected. At times we see incorrect justifications used, particularly when it comes to a company or association. If the outgoing party has changed their name, whether it is an individual or company, the first question to ask is how and why their name was changed. For example, for a company, was it a change of name through ASIC, being an incorporated change of name, or a transfer of assets, being an organisational restructure? For an incorporated name change, ASIC evidence is held in your file and is not required to be produced to this office. For an organisation restructure, if evidence has already been lodged, this should be referred to in the mortgagee panel as per the example. Or, if it is a new organisation restructure, evidence should be attached to the first dealing lodged in Land Services SA. It is important to note that any dealing where the party is not disposing of their entire interest, is remaining on the title, or has an existing interest in the same title, an application to note change or correction of name must be lodged in series with or prior to the dealing. As per Notice to Lodging Party number 162, the practice of not disclosing a consideration amount is not optimal for those property professionals who rely on this information. Under all situations where a consideration has been paid, it is imperative that the consideration should be disclosed within the appropriate panel to ensure transparency of property transactions. When entering the consideration, please ensure you enter the amount in dollar figures only, as this will automatically populate into words. The only time additional text is required is when referring to a trust, a will, a deed of assignment, a court order, or other information that is pertinent and applicable to the transaction. Remember that whatever is entered in this field will appear on the rendered form and be certified correct by you. It is also important to remember that registration fees on transfers are calculated on the higher of the stamp duty value and the consideration panel value, unless stamped exempt by Revenue SA. Where the consideration panel states a higher value than the stamp value, additional fees may be required. These can be presented to this office on the day of lodgement, or alternatively, the dealing will be requisitioned. It is important to select the correct entity type for an incoming party, as this will affect the inclusion of an ACN and impact the creation of ownership and valuation records. On the slide, you can see that there are 6 options for entity types, the most common being private and company. If ever in doubt, refer to your verification of identity documents to confirm before proceeding. The incorrect entity type selection could result in a correction of name being required. Abbreviations acceptable under the Corporations Act 2001 are used in SALIS and will automatically be applied to an incoming party. For addresses, SALIS was built to adhere with the Australian Business Standards. This document is viewable on the Australia Post website. The registered address is used for notices from this office and by government billing authorities, making it essential that a viable postal address is supplied and entered in the correct field. In this slide, we are focusing on a company and how and where the ACN should be entered. There have been numerous dealings lodged with this error. Please ensure that the ACN is only entered into the ACN field and not repeated in the name field, as highlighted in the red box. If it has been entered more than once, the rendered image will populate with the ACN reference twice. The ACN must be for the company described. Reference cannot be made to a trust or trustee's ACN or ABN. Section 162 of the Real Property Act 1886 prohibits the Registrar General from registering an instrument which refers to trusts. Within a mortgagor panel, trust details are not permitted unless the mortgagor is registered on the certificate of title as such. For example, the mortgagor is registered in a fiduciary capacity, such as executor of a deceased estate or pursuant to the Trustee Act. Within a transferee or mortgagee panel, no reference whatsoever is to be made to the fact that a transferee or mortgagee is acting as either a trustee or a personal representative. So, for example, the inclusion of the words as trustee or as the executor of the estate of AB, the deceased, are not permitted in either the transferee or mortgagee panel. The one exception being the mode of holding with no survivorship, which can be inserted for the incoming parties when applicable. For a transfer, details relating to a trust may be included within the consideration panel. It is a common error in both paper and electronic lodgements that the executor's capacity is described incorrectly. It is important when selecting the executor capacity that you check the probate to confirm how the executors have been appointed and that the correct option is displayed in the applicant panel. The first example is a standard grant of probate where it has been granted to one or more executors. The capacity selected should be executor. The second example describes an executor with leave reserved, allowing for another executor to apply for probate at a later date. The capacity selected should be executor with leave reserved. If the probate is older than 6 months, it is recommended you conduct a search of the probate registry to ascertain whether a grant of double probate has been made in between the issue of the first grant and the lodgment of the transmission application. The requirement for a further search is even more important prior to transferring from an executor with leave reserved, and results of this search should be retained in your evidence file. To avoid requisition, ensure that the name of the deceased, the date of death, the probate or letters of administration date, and whether executor or executor leave reserved is entered correctly into the PEXA workspace. When an electronic dealing is subject to a caveat that requires the written consent of the caveator, there is no option in PEXA to facilitate the attachment of the consent to some dealings, such as a transfer. Consents that cannot be attached to the dealing but are required for registration can be emailed to our customer support or client advice registration email address, or alternatively delivered in hard copy to our office. Once received, we will attach the consent to the dealing, and this will form part of the dealing image stored on Salus. The electronic requisition process differs slightly to the paper process. When a requisition is raised on an electronic lodgement, the dealing will be converted to paper, have a barcoded number label affixed, and the requisition notice will be attached. These dealings are available for collection from Land Services SA or posted as per your ELNO agent code details. It is the responsibility of the party receiving the dealing to make any amendments to dealings they have certified, and when required, forward any other certified dealings that have been referred for requisition to the appropriate party. A requisition notification is sent by email for all paper and electronic corrections. Requisitions being collected from Land Services SA are available after 11 a.m. on the day that you receive the email notification. Please note for electronic lodgements, if you wish to change the method of requisition delivery, contact your electronic lodgement network operator to organise an update of your delivery details. Land Services SA's website has a wealth of information, guides and tips relating to e-conveyancing on our e-conveyancing webpage. Available on this page are a detailed list of dealings that are mandated for electronic lodgement, information and circumstances relating to dealings exempted from electronic lodgement, a downloadable list of residual dealings available for electronic lodgement and requirements for the ELNO workspace, and a list of all published e-conveyancing tips of the month. These have been released since May 2022 at the beginning of each month to address current issues or errors relating to electronic lodgements, and contains many helpful tips to ensure the accurate completion of the electronic workspace. To summarise the key points of today's webinar. Point 1. Attachment should not contain panel form pages or certification pages. Point 2. Where a party has changed their name and is disposing of their entire interest, a name tie-up and justification is required. Where the party whose name has changed is remaining on the certificate of title and is not disposing of their entire interest, or has an existing interest in the same CT, an application to note change or correction of name is insisted upon. Point 3. Enter the entity type correctly and as per their verification of identity documents. Legislated abbreviations under the Corporations Act 2001 will always be used in SALIS. Point 4. Check the probate for the executor and executor leave reserve capacity. This must be referenced correctly in the dealing as per the probate. Point 5. KVTOR's written consent that cannot be attached to the electronic workspace can be emailed to Client Advice Registration Officer at landservices.com.au. Point 6. For electronic dealing requisitions, the dealing will be converted to paper, barcoded, and be delivered as per the preference set with your ELNO agent code. This dealing is now the original and must be returned. To update your delivery details, please contact your ELNO. Land Services SA's website has a range of educational and support materials to assist you in your day-to-day work. Our Industry Education Hub is a good place to start. This can be found by clicking Industry Education Hub on the home page of Land Services SA's website. A copy of today's webinar will be published on the Industry Education Hub together with recordings of previously held webinars. That concludes the recorded webinar section. Thank you for listening. Please remain online for the live Q&A session with our subject matter experts.